This is Talk Business and Politics with Roby Brock.
Welcome to today's Talk Business and Politics Daily. I'm Roby Brock. I'm joined by Justin Allen. He's with Wright Lindsey Jennings, attorneys at law, and he is a Talk Business and Politics contributor. And man, we had a little curveball thrown at us from the Arkansas Supreme Court late last week, and I want to set you up with a couple of questions to answer exactly what happened. What did exactly the Arkansas Supreme Court rule in terms of sovereign immunity with the state of Arkansas?
Yeah, the basics of this case, Roby, were that an employee at Rich Mountain Community College sued the college, which is part of the University of Arkansas system, for a violation of the state minimum wage law that was passed by the Arkansas General Assembly, saying that the state had violated it. The state moved to dismiss the case, and ultimately the Arkansas Supreme Court said, yes, you cannot sue the state in this instance. It's immune from the suit under the doctrine, decades, centuries-old doctrine from English common law of sovereign immunity that you can't sue the government. And so the court referenced Article 5, Section 20 of our state constitution that states that the state cannot be made a defendant in her courts, and the majority opinion said that means what it says. You can't sue the state, and it can't be in this court, and therefore it was dismissed.
The state has been sued before on many big issues, such as Lakeview, for instance. Why is this ruling a break from precedent or potentially a return to precedent that had been broken?
It's funny because it's both, right? For about 60 years, beginning back in 1930s, the Arkansas Supreme Court ruled that you can't sue the states in court and that the legislature cannot waive that immunity by statute or otherwise. And then in the 1990s, the court broke from that precedent and said, no, you can sue the state in court if the legislature, through statute, waives sovereign immunity. And that's been the rule for close to 30 years now. And then last Thursday, the court said, we're going back to the way it was back in the 30s. The legislature cannot pass a statute waiving its sovereign immunity. Case dismissed.
So big question, what are the potential ramifications? I mentioned Lakeview, but there are many, many other examples. Give us a few.
Well, Lakeview is a huge one. The question now is, can a Lakeview-style lawsuit be filed? If the General Assembly fails, in the opinion of some people, to adequately fund education, will they even be able to hear that in court? Freedom of Information Act, that's a legislative waiver of sovereign immunity whereby the state can be sued in court. Is that still effective? Illegal exactions. As pointed out in my recent piece on this, the general improvement funding cases have been illegal exaction cases, and as you well know, those are the cases where the court ruled that the General Assembly cannot spend that excess funds in the way that it has. And will that even be a lawsuit that can be brought in the future?
That's interesting stuff. So what are some potential remedies or changes? It sounds like a legislative fix is probably not going to correct a constitutional problem.
No, I mean, the court said the legislature can't waive it. One legislative way to address it would be whether it's the Claims Commission or creating another administrative route to bring these claims, but that's going to grow government and cost money, and I can't imagine the General Assembly is going to be thrilled about that. Another way this may shake out is through additional litigation, where litigants file suit against the state and try to convince the court that this is different, that, for instance, we're not asking for a money judgment such as a Freedom of Information Act claim. We're asking the state to comply with law. I think there's a possibility the court ultimately could be convinced that that is different. And then the other thing that would be done is, it's a constitutional issue, amend the Constitution and modify that language as it relates to sovereign immunity.
You see that one on the ballot and people trying to understand, what am I voting for in this one? It would be complicated. All right, Justin Allen has written a column for us on this very subject. You can read more about it at talkbusiness.net. It's a good read, and it will help define some of these things that we've talked about here. Appreciate you turning that so quickly, Justin.
Absolutely, my pleasure,
All right,
Roby.
good to see you.
Thank you.
And thank you for tuning in. That's all for today's Talk Business and Politics Daily. I'm Roby Brock. We'll see you next time.
Arkansas Electric Cooperative Corporation provides electric energy across 2/3 of Arkansas. This is an exciting time in our energy history, with incredible progress being made in renewable energy and storage technologies. As our energy portfolio continues to diversify, we'll maintain an all-the-above strategy to provide reliable and affordable electricity. Ever since the first light bulbs were placed in our members' homes, the electric cooperatives have been the solutions provider for our members, and we want to continue that well into the future.
Each day, the promise of our nation begins again. Arkansas, and America moving forward. I help make that promise a reality. It's not for everyone, but people everywhere depend on us.
Oh, I love you too, sweetie.
Trucking delivers, or everything stops. And that's what drives me.